All right, people, I think we are live. The camera is going to be slightly lower quality this week because I forgot my, they have a word, not a dash cam, whatever. I forgot the camera in Montreal. I'm at my mother-in-law's place, as you can see by the beautiful decoration in the back. So I forgot my camera and my mic. So I'm using the cam on the computer and the earbuds. How does the audio sound to everybody who's already in on this chat? Let's say, don't do F, do Y for good and N for bad. And I'll let everyone, yes, I hear you. Okay, good. Likely story, Viva. What are those things called? If Nate is watching, the plug-in cameras. Anyhow, all right, so standard rules, I'll do the intro. I see Robert Barnes in the background. He is looking extremely dapper yet again. One day I'm going to wear a suit and tie and surprise everybody, but not when it's 33 degrees and excessively humid. Webcams. Thank you. Why is 923 taken? The webcam. I forgot my webcam. So we pulled this audio. I'm going to turn it into the podcast audio with the help of Eric Hunley from Unstructured. So if anybody doesn't know who Eric Hunley is, he also does live streams, podcasts. I actually did two podcasts with Eric Hunley, Unstructured. He sends me the audio. Then we turn it into a podcast on Viva and Barnes, Law for the People, which is on iTunes. What else? Podbean, Google. It's on the standard ones. So that's it. I'm going to get to the super chats in as much as possible. Reserve the right to not get to all of them because I never do and I feel guilty, but it's par for the course now. Going to try to get to as many non-super chat questions as well to spread it out so that it's not just a paying thing to be able to have your question read. I noticed one super chat at the beginning already, which said, am I going to do a video on Trudeau? I may have to do a video on this latest scandal because it's an interesting thing, just reading the comments online where the scandal in a nutshell is Trudeau's mother and brother had been paid together about $300,000 in speaking fees to speak at a charity called We Charity over the last 4 years. Some people saying, what's the big deal? They have to, they're entitled to make money. Others saying nepotism to the point of corruption, whether or not Trudeau ought to have excluded himself from discussions about granting a contract to this agency that in turn pays his family and pays them well. Okay, get my dad back on. Who said that here? Jason McConnell says, get your dad back on. Greg in the house. Where are you? Not Montreal. We're just outside of Montreal at Eastern Townships. It's a beautiful place. Fishing is great. Joshua Cornelius, first stupid says, $1 million idea. Start making masks with Trump's face printed in them. Watch people lose their minds. I have a number of ideas for creative messages on masks, but I don't want to look like I'm exploiting the pandemic in any cynical way. Okay, so that's it. So on the menu for today, this afternoon, for now, we're going to do Flynn. Obviously, we're going to talk Flynn. If anyone hasn't seen, I put up a follow-up video yesterday, which was earlier than specifying the delays now that Michael Flynn has to respond to Judge Sullivan's petition for rehearing en banc before the Court of Appeal. We're going to talk about that. We're going to talk about stone commutation because there are some terms in here that I know people need clarification on. A couple of the SCOTUS decisions about Trump's tax returns. And what was the other one? Oklahoma, which was drawing a lot of attention. I only read articles summarizing it. I did not read the decision. I think I have an idea of it, but I suspect Robert is going to have a much better idea than me. So let's see what we got here. Let's do it. We're going to bring him in. I see Robert. Oh my goodness, I actually see Robert. How you doing?
Yes, I've been getting complaints about not smoking the cigar, so now it's smoking.
That's yeah, and you know what's funny? I guarantee you, YouTube might. I hope they don't have a problem with it in real time, but I guarantee you, smoking a cigar on YouTube is a big taboo these days.
I didn't know that.
We'll see.
Even more reason to do it.
If the stream goes down, we'll repost it ASAP.
Yeah.
Let's see this here. So first of all, how are you doing, Robert? You're looking good.
Good. Going up to Virginia tomorrow because I have a trial about ballot access and petition circulating rights in a pandemic in Virginia in the federal district court in Roanoke. So going to trial on behalf of the Libertarian Party, Constitution Party, Green Party, the Independent Green Party, The Independent Green Party runs in Virginia because the Green Party doesn't field as many congressional candidates as they would like. For people running to be on the presidential ballot, Senate ballot, and House of Representatives ballot. And so we'll see what happens. I think we'll get some relief, maybe not as much as I would prefer, but it should be an interesting trial. The judge is an expressive personality, so that's always unique. So we'll see how it all goes.
And you need to do this, have it tried, and you need a judgment within what time frame if this is for the upcoming election?
Well, effectively, I mean, the deadline to get on the ballot for Congress is actually already passed. So we're looking to have that moved to August. And then the presidential ballot deadline is already in August. And so it's about time to get on the ballot. They really don't start printing the ballot until mid-September in order to meet the 45-day obligation to send out military ballots. So the real hard deadline, if you will, is a final decision by early September. But I anticipate the judge will issue a decision within a week or two.
Amazing. And it's going to be a written decision. It's not going to be rendered on the bench?
I would be surprised if it was rendered on the bench. So he's already made clear he's not inclined towards certain remedies that I want, but he is open-minded as to the remainder of the remedies. And so it may go up to the Fourth Circuit and the U.S. Supreme Court if either side is unhappy with the decision.
Okay, and amazing. And in general, actually, you don't have problems talking about certain pending cases like this. Is there any strategic disadvantage or risk about talking about these cases?
Now the trial's on Monday and sort of the cat's out of the bag. Most of the facts are not in dispute. Really, the only fact that's kind of in dispute is the degree to which you're not able to get signatures. The state recognizes that the pandemic makes it much more difficult to get signatures, but they don't agree as to what percentage of signatures have been reduced. That's really the only fact that's in dispute. Otherwise, what we're requesting is allow signatures to be gathered electronically, allow them to be emailed, allow them to be digitally scanned, waive the witnessing requirement. What they call wet signatures, a physical signature, is really the biggest hurdle in a pandemic. And several of my clients, they're on different parts of the political spectrum as to the pandemic, but several of them believe that that they pose a risk of health to themselves and to others if they circulate petitions in person. So they don't understand why that they should have to risk death in order to just simply get access to the ballot. And I think their position is a reasonable one. And the state's position strikes me as contradictory. Michigan has similarly taken a contradictory position where I have other litigation against the state of Michigan. And their position appears to be this virus is so dangerous that you cannot protest the lockdown, that it's selfish to do so, that you cannot go to your job in many cases, that you cannot operate your business, that you cannot sing or even gather in church in most cases, that you cannot send your kid to school. But magically, all of that dangerousness disappears when it comes to circulating petitions to challenge the two parties on the ballot. So that to me doesn't strike me as a consistent position for the state to hold. So the only question, in my view, should be how much the signature restriction should be. How many signatures should be required, given the number of signatures that are difficult to gather, whether they should have to be gathered in person physically and witnessed, as is currently required in Virginia, and whether or not the signature requirement even makes sense when there's no evidence that having too many choices on the ballot causes voter confusion. So the last one is the one the court has told me he's not inclined to grant. That's the main request I made, but we're fine with other alternative remedies. Some parties have already settled in the case. So we'll see. I think we'll get something, maybe not quite as much as we would like, but I think they'll get something. And I think many of them will end up ultimately on the ballot because of the remedy we're able to obtain. Amazing.
We'll follow up when that happens. Okay, and before we get into the first subject, I'm going to try to get through these super chats real quick. Jessica Cora says, being that the power to pardon and commute sentences is clearly absolute in the Constitution, can the Democrats actually follow through on their threats to punish Trump? We'll get
no.
to that. But
Pelosi's full of it. I mean, she's talking about passing a law to ban it. No, you can't pass a law to ban it. And nor is what Trump did anything extraordinary. Every president has commuted and pardoned people that were his political allies or family friends. That's not new at all. Bill Clinton just took it to a whole new level.
Yeah, and so someone had posted. Oh no, it was Robert. It was your post. People were correcting that someone. It was One of them was Nixon that pardoned, and not. I get
Well,
one
yeah,
of them was not.
Kennedy pardoned a major Las Vegas news publisher who had all kinds of dirt on the Kennedys. He was involved in gun running to Israel and other activities. Then, of course, I mean, everybody's pardoned or commuted, far more people than Trump has on average. Of course, Clinton famously did it. He famously commuted Susan McDougal's sentence, who could testify against him directly. Also commuted the sentence of commuted the sentence of the famous terrorist that ended up becoming associated with BLM. Pardoned his own brother. Of course, pardoned Mark Rich, who gave him a large donation. Poppy Bush, of course, commuted or pardoned people that could implicate him in Iran-Contra. W pardoned or commuted the sentence of Louis Libby, who could incriminate him for crimes committed during the administration. So what Trump did was very light. I mean, what Trump did was commute the sentence of someone who was not part of the administration, who could not implicate himself, President Trump, in any crimes during the administration, and who, in fact, was probably the most problematic political prosecution in a recent era, other than General Flynn, in terms of what happened in the Roger Stone case.
Actually, that's exactly what Patrick here with the super chat says. How is it that all these people like McCabe, Stroke, Page, Brennan all lie and nothing happens? But if you are friends with Trump and lie about what you had for dinner, that they try to lock you up for years. We're going to get into the details of what Stone was ultimately convicted of when we get to Stone. It is amazing. I mean, the pardons that have gone on in the past, it's a double-edged sword to some extent, because it sort of says, well, if Bill Clinton and Nixon and all these other guys pardoned people wrongly, then Trump shouldn't do it either. But who Trump is pardoning in comparison to who has been pardoned in the past, it's shocking for anybody who doesn't know. And listening to you explain it, now I understand why people on Twitter are thinking that Trump pardoned Stone because he had some incriminating information on him to buy his silence. From my understanding, that was not a realistic expectation. It was just it was pardoning what was ultimately a political prosecution from the beginning.
Exactly, and the judge made it easy for him to do so, because the judge was so rogue in the way that she handled this case. I mean, there was manipulation of the venue, there was manipulation of judicial assignment, there was manipulation of jury selection, there was manipulation of discovery, there was manipulation of sentencing, all of it. Everything you could possibly abuse, this judge abused to deny Roger Stone a fair trial, making it easy for President Trump to commute him.
Oh, and who is the judge again in Roger Stone?
Judge Jackson.
Judge Jackson, which is the same judge in
Paul Manafort's case.
Okay. Was she not involved with no, never mind. I'm sorry. I'm thinking of Michael Flynn and the target that he allegedly, posted when he posted a picture of Judge Jackson, which got him gagged on social media.
Yeah, which was also absurd. It was an absurd interpretation of the nature of what was in the background. Secondly, judges need more criticism, not less. They're not free from criticism, unless what you're doing was imminent risk of violence. And to give people an example, Brandenburg case or the Stokey case, the Nazi Party actually went through the community that had the highest per capita number of people who had relatives suffer in the Holocaust, and the Supreme Court said that was constitutionally protected activity. The Klan could call for violence against black people within the local community. That was constitutionally protected activity. Yet putting a picture of saying this judge is biased, and in the background just being what really is more like a cross symbol, it was somebody's background symbol, and interpreting that somehow as such imminent risk of violence to her that it endangered her life. Complete gibberish, complete nonsense, complete garbage by this judge who wanted to hype up her own poor victimhood status in order to justify constitutional violations that were routine and flagrant. I said criticisms close to that during the proceedings because there was a chance I might represent Stone, so I didn't go as far as I just did. But the judge's behavior was some of the most disgraceful, disrespectful behavior I've ever seen in the federal bench. And so she is the reason. If all the people that don't like the Roger Stone commutation, take it up with Judge Jackson, because she created the easy political predicate by which President Trump could commute that sentence.
And you know what? I think we're going to have to start with Roger Stone anyhow, now that we're this far into it. I'll just read a couple more super chats. Mark Watson says, de Blasio cancels all large gatherings except for BLM. Legal seems like it should be all or nothing to justify emergency powers.
It's clearly political discrimination. He's doing the same vis-a-vis allowing BLM to have certain murals painted on the public streets, but not allowing others to have murals painted on the public streets. So Mayor DeStasio, as I like to call him, continues to live up to his reputation. He's busy worrying about dog walkers in the park and regulating their behavior, making sure they get criminally prosecuted if they don't use politically correct terminology, or he misinterprets what took place, while people are getting shot and dying in New York on his watch. I mean, the guy's one of the most disgraceful mayors in the history of the city of New York.
Okay, I'm going to read these. We're not going to be able to answer them, but Alex Kasparovicius says, if inherited guilt reparations becomes law, wouldn't that also open the door to children being liable for their deceased parents' debt or crime?
Yeah, blood libels are a bad idea, period. We should have learned that over the last couple of hundred years. Whenever we've applied a blood libel, it leads to horrific moral tragedies. So they're bad ideas in general. I think the only argument for reparations can't be a blood libel argument. It has to be a restorative argument, an argument that some communities are disadvantaged institutionally because of the past, and we simply want to equalize the playing field. That's what affirmative action was originally pitched and promoted as. I'm not as confident that it works in the way people say it does, but my brother is a philosophy professor, supports reparations on those grounds, not on blood libel grounds, but on grounds of there some people are disadvantaged today because of rights that were denied their ancestors. So we as a society should try to equalize that and balance that out, not because anyone else is guilty of anything wrong, but because we want them to be in a better position today. Sorry.
We know what jokes are coming in the comment section now.
No doubt whatsoever.
Okay, we got Little Rock, Arkansas. Little Rock says, I just lost my qualified immunity, one at the district level at the 8th Circuit in St. Louis. And I'll give you a chance to. Okay, you know what? So let's go back to the Roger Stone. We'll start with Roger Stone. We'll move into Flynn.
Yeah.
Roger Stone was convicted of witness tampering and lying to Congress, correct? There were seven different convictions.
Effectively, they're all process crimes. So what it boiled down to was Roger Stone was being investigated for whether or not he had any ties to WikiLeaks. He had exaggerated his ties to WikiLeaks during the campaign, and he was still trying to cover for that during some of the investigation stage. So Roger is a notorious exaggerator. He's in the political consulting business. That's what he does. And so he got caught exaggerating, and he was trying to cover for that exaggeration. So he didn't disclose certain details that they later decided they were going to call criminal. The reality is none of it was material. It's the same problem as the Flynn case. Nobody in the committee felt that anything that Stone told them prevented them from doing their job or their task. Number one. Number two, there was no connection to WikiLeaks. Roger never had it. Roger knew some people who knew some lawyers who knew some people who knew Assange. He had no direct ties to Assange, as anyone who would have known Assange and known Roger would have known. In fact, I said so back in 2016 at the time. I said, Roger doesn't have a tie to this. This is just Roger being Roger. So take him with a grain of salt, or a pound of salt, as the case may be upon occasion. And for all of that, and then Roger used to get into aggressive repartee with a friend who was a potential witness. And they used to threaten each other all the time, but not in real terms, but in just exaggerated terms. The way they do in politics all the time. We're going to go to the mattresses, all this aggressive Godfather rhetoric. And based on that, they said that he tampered with a witness. The witness that was supposedly was tampered with said they were not tampered with at trial. Said they did not feel threatened, did not feel intimidated, and that Roger did not belong in prison and shouldn't be prosecuted. So it's extraordinary. The Congressman Nez, who ran the committee, supposedly was lied to Roger for prosecution and did not believe Roger had materially deceived them, and and did not obstruct the proceedings. And the witness that was supposedly tampered with said he wasn't tampered with. That was the criminal case. It only could be prosecuted because they chose DC to charge it when they could have drawn it in other venues, because they manipulated the assignment of the judge. It did not get random assignment of judge, which was supposed to happen. Instead, it was manipulated to get in front of Judge Jackson, who'd already expressed and exposed her bias in the Manafort-related proceedings concerning Trump, who then gagged Roger and prevented him from defending himself in the court of public opinion, also prevented him from outing problematic jurors because he wasn't able to disclose juror information that could have been investigated and vetted before trial rather than after trial, as ended up happening, was denied opportunities to get meaningful discovery, was denied opportunities to present meaningful parts of his defense, then had a jury that was a complete joke. It was worse than a early 1960s Alabama jury in To Kill a Mockingbird kind of case. And then that got exposed after the trial. Judge still covered it up, then gave an excessive punitive sentence, then demanded, even though he is an older defendant who's vulnerable on COVID, to immediately report to federal prison. So it was the most egregious sequence of procedural. If you want a test case to study how can you abuse the judicial process against a criminal defendant, there is no better example than the Roger Stone case. There's aspects of Flynn that are more egregious, but not from top to bottom, left to right. There wasn't the manipulation of venue and the manipulation of judicial assignment and the manipulation of jury selection and the manipulation of the sentencing procedures and manipulation of discovery in Flynn. All of that happened in Roger Stone's case.
And just so everybody also fully appreciates, when Roger Stone lied, it was about knowledge that he didn't have and not about concealing knowledge that he did have. So this is one thing. This is like another one of those journeys that I went on, because when he first got convicted, I had no idea who Roger Stone was. The first thing I found out was that he has a massive tattoo of Richard Nixon on his back. It's not a bad tattoo. It's aged relatively well. So I knew nothing of this from the beginning. The lies that he was convicted of were lies about knowledge that he didn't have, not concealment of knowledge that he did have. The witness tampering consisted of a threatening text where Roger Stone said something about, I'm going to get your dog, or I'm going to take your dog, to this guy. Not knowing the context, it could sound like, the Godfather waking up with a horse in your bed, a horse head in your bed. Knowing the context, one would think, one can really have some second ideas as to whether or not it was a bona fide threat, or even ever intended to be a bona fide threat, to the point of witness tampering. So there were 7 convictions, but 5 of them were lies, which were all relatively the same, and then the 2 witness tampering. And so how many years was he going to get sentenced to, or had he gotten sentenced to?
Well, originally the insane prosecutors on the case wanted the most disproportionate sentence in the history of such cases, like a 9-year prison sentence. Ultimately, I think it was around 3 to 4 is what the judge came in with. Still insane. A longer sentence than most rapists face in state court systems across the country. For a guy who's over 65, has no criminal history at all, for which there is no victim testifying, neither Congressman Nunes, whose committee was supposedly lied to, nor the witness who was supposedly tampered with. Both of them are saying he shouldn't be prosecuted and doesn't belong in prison. And so it was an insane sentence, an insane judicial process from top to bottom, left to right. And it was the worst, most unconstitutional gag order in the history of a criminal case that I've seen in the last 50 years.
Someone said apparently if Trump pardoned him, Stone said he would get a tattoo of Trump on his body. I'll see if I can.
I'm sure that's coming. I have no doubt. And there's a famous meme of Roger dancing to a famous rap song that is going around viral right now in the web. And what is 2 aspects. People hate Trump, so people hate Trump, and they interpret Roger Stone in that light. Those that hate Trump, and then there's people who hate Roger Stone because they believe his exaggerations. I first worked with Roger Stone on the Joe Francis case, Girls Gone Wild guy, many years ago. And God bless Roger, but as I said at the time, so I'm not saying anything new, he was a notorious exaggerator even then. And in fact, we did not get along on that case because he wanted to bring in other people who were a complete disaster and some other aspects. So Roger has unique skill. He also gets himself into unnecessary trouble, but most of the things that the people on the left hate him for are things he actually, I don't believe, ever actually did. I don't think he caused Elliot Spitzer to get exposed. I think he just took credit for it after the fact. So Roger sort of had this aura of, I'm the great dirty trickster who can do magic behind the scenes. None of it was really true, or at least not since 1972. But Roger came up as an outsider, like Kevin Phillips with Nixon. So there were all these sort of middle-class ethnic Republicans, late 60s, early 70s, sort of like Trump's father, who came of age as Republicans, but were not your old, your old fur coat, Northeastern establishment kind of Republicans, as Republicans had been since really the early 1900s. So they were not part of, and so there was that. They nurtured this contrarian, willing to do whatever it takes, politics is war mindset. Roger then became involved with a lot of lobbyists, including Paul Manafort and others. And they lobbied for some questionable groups, let's put it that way, in the 80s. Then he stepped back from that. He's been long associated with Trump, tried to convince. He has a unique political skill set. But what he's mostly known for, as people can see in the documentary Get Me Roger Stone, is a dirty tricks image that, in my view and in my experience, and I have reason to know, has been mostly exaggeration. Now, I used to pitch to people, if Roger's this good that he can create this image that he's a master dirty trickster, he probably is good at political consulting because he can create crazy images regardless of their connection to empirical veracity. But as a whole, most things people hate Roger Stone for, he really didn't do. They don't realize he's just an exaggerator.
Well, so I mean, when I was doing the first video I ever did, you know, I found, first of all, there's that deposition where his behavior is somewhat eccentric to the point where it can irritate people or it can turn people off.
Well, and if you want to see an uncontrolled deposition, let's see some of Roger Stone's depositions. You want to see a guy go crazy in a deposition. Dear Roger, he really just lost it. Now, he was under a lot of pressure in some of those depositions. But when people, questioned how Alex Jones handled the deposition, which I think he handled it just fine. But if people are like, well, yeah, that's how I got to know your analysis of that deposition. But we watch a Roger Stone deposition. That's when your client. That's when you're like, please, client, please don't talk anymore, please. But he was cussing and screaming and yelling, and he was ready to shoot that guy.
His behavior. I mean, I described it as manic, but not from a clinical sense. Just like moving, fidgeting in his chair, mouthing "F you" to the other lawyer. It was comedic in a way, but it's also sort of tragic in another. But speaking of like people who want to hate Roger Stone, here the Florida man of YTube comments says, Stone effed up by choosing to joke about threatening a state's witness with death to a state's witness. He may be a douchebag, but I don't see him being, even by his own imagination, Michael Corleone.
Exactly. He clearly shouldn't have talked to people. Why he kept talking is beyond me. He also was the one who wanted to testify. And I was telling people close to him, this is not well advised. Never volunteer. But, Roger's Roger.
And another thing which might justify people's hatred. He started an anti-Clinton organization, and it was called Clinton something. I forget the acronym, but it spelt the C word. And then apparently he explained that he did that because they couldn't think of an acronym for BITCH. So he's done a lot of things that might make him detestable to some people.
Yes. Just watch, it's gone viral. He and Alex Jones notoriously trolling the Young Turks at the Republican National Convention in 2016, where Cenk Uygur goes nuts and just loses his brain for a little while. Okay. So there's a part of Roger that's a master troll. There's a part of Roger that's naturally provocative. And he was Trump's provocateur on the outside in 2016. So even though he's not working for Trump formally or officially, he wanted to see Trump get elected. And he and Jones are the ones that came up with the idea of taking the Obama Hope T-shirt and just making it a Bill Clinton rape T-shirt. So that they did a lot of stuff. I understand why people get agitated on the other side against Roger, but a lot of their agitation is based on believing his exaggerations are true about in terms of quote unquote dirty tricks. Most of that stuff is exaggeration.
And now, I mean, and this is not to defend Roger. I don't think Roger as an individual needs defending. It is to explain possibly why it was so excessive. This was his first criminal conviction in his life at this point, I think.
Yeah, first criminal charge ever. So this was a guy who, for all the talk about him being connected to Nixon people and him bragging about dirty tricks, there was no evidence he was actually involved in any illegality. Now he was connected to Roy Cohn. He met Roy Cohn as a way to help Ronald Reagan win New York in 1980. And he tells that story. People can look it up themselves. But Roger's actually always been careful to stay within the legal limits of things. So that's where the only thing he thought he could get away with is exaggeration while under oath and while interacting with witnesses. And that's where he made his mistake. But it never should have been criminalized. And by contrast, it's nowhere nearly as egregious as the perjury committed by CIA Director John Brennan or by Director of National Intelligence James Clapper, who lied about material things that were actually pertinent to both the committee and the country, who have never been criminally prosecuted at all. So for those people who are making comparisons, there was a selectivity, not only to the venue choice and the judicial assignment that was manipulated for jury selection purposes ultimately, but also selectivity in the prosecution in the first place. Because if they prosecuted everybody who ever lied to Congress, half the people who've ever testified to Congress could be prosecuted. That's just the reality of it.
And it's amazing. And I want, people should appreciate that before, coming to the conclusion that there's no order or rule of law because Trump is pardoning his buddies. How old was Roger Stone right now? He's 67 or 69?
Yeah, I think now he's 69. He was 67 when they did that. I mean, that was the other ridiculous thing. They did a live SWAT team raid that magically CNN got to videotape. I mean, everything about this was to create the perception of criminality around Roger Stone because they didn't have a real criminal case worthy of prosecution. They could only get a conviction by bringing it in front of that judge and that jury, and by treating something as criminal that they normally do not.
So everybody appreciates this. First-time criminal conviction on two, I would say minor charges, but two charges.
Process charges.
Process charges. 67 years old at the time. Was initially going to be sentenced to multiple years, but nonetheless 3 years for somebody who's 67, 69 could very well be the end of their life. And then you compare that to what does not go charged or punished elsewhere, and you can then come to your own conclusions. And if it's the same conclusion, we might have some judgment differences of opinion. So Trump commuted the sentence. So I mean, I know some people are not clear on the difference between pardon and commutation of sentence.
So the advantage of a commutation is it allows you to challenge the conviction in the appeals process. A pardon vacates the case. So a pardon, Stone came out and said he thought a pardon meant he would have to accept guilt. That's not really true. I've never accepted that assumption about a pardon. Nixon never accepted guilt, and he was pardoned. He was pardoned without even a prosecution. But the advantage of a commutation is it allows Rogers' appeal to go forward. So they can still vacate the issues of the gag order, the issues of everything that took place in that case. The D.C. Circuit will get a chance to address. U.S. Supreme Court, if they want to, will get a chance to address without any consequence to Roger. So Roger's never going to serve a day. Now, a consequence in the sense he is a felon right now. So that puts limitations on what he can do. But to his sentence is when you commute the sentence, it's as if the sentence has been served. So that's the effect of it.
And if say vengeful political adversaries want to go back after Roger Stone, is this sort of a commutation, or I want to say a pardon, but is this a commutation of any and all related crimes?
Yeah, relatively, because it's covered by double jeopardy. Because it's like when your sentence has been commuted, it's as if you served it, and so to prosecute you again would be punishment for the same offense twice in violation of the double jeopardy clause.
Someone says, Peter Brisdall says, do you have over 3,000 trolls or just globalist believers? If not, smash the thumbs up button. That is because I think, Roger, this might be a new peak, 3,691 live viewers.
Sweet.
So, okay, so Roger basically, off the crimes for which he's been charged, is off scot-free with the, let me just bring this off, off scot-free with the caveat that he's still a felon. Is there a chance that political adversaries start digging deeper to see if there's other charges that they can get him on of things that have yet to come to the juridical fore?
I don't think so. I mean, there's always a risk, but if there was anything there, they would have added to it. So now he still faces all these civil suits he has to deal with. He was partially bankrupted by the criminal case, so he's going to have monetary issues still ongoing. But he's not going to serve a day in prison, in my view. I don't think anything else will come down the pipeline to cause that to occur.
Okay, excellent. And now, before we move on to the next topic, which is Michael Flynn, I took two pictures of super chats which I missed. Gregory Rolf says, given how political a lot of cancel culture is it possible that some of the cancel culture stuff can be treated as voter intimidation? And Dwayne Olsen says, Robert, do you have sites, links, articles for Pew and Gallup dropping out of presidential polling? It says makes an interesting compare-contrast for the recent Stony Brook primary model results.
Yeah, so I mean, in terms of the Stony Brook, they're referring to Professor Normuth. I'm blanking right now on his name. It's my first one's like Helmut or something, and Norpoth or so whatever. It's a weird name, but his model is similar to one I use, and it's accurately predicted 25 of 27 presidential elections, and it says 91% chance that Trump wins. So that's why they're referencing that. Pew and Gallup, you can just Google it. Pew not to poll 2016 election. And the article should come up. Same with Gallup. And so they were the gold standards of presidential polling since the 1980s. And both said that polling had become so unreliable that they were no longer going to make a presidential prediction poll. So they're still polling it, but they're not pushing the results of that. Well, Gallup's actually not polling it at all, but Pew will occasionally poll it, but they're not actually pushing their poll results as predictive anymore. And so it's a sign that the polls will be very unreliable as they move forward. And I'm momentarily forgetting what the first super chat question was.
Oh, it was voter intimidation from cancel culture.
Yeah, I mean, to a certain degree, if it's done by the state, if it's done by the state, then maybe it would be a novel theory. But technically, cancel culture is mostly done by private citizens and private participants. So there's only so much one can do. But there is a question about to what degree is it election interference? To what degree is it actual election criminality? Because the language of election interference that was applied to the Russian troll farms was really never a crime. I mean, that was always sort of bogus, unless they could show direct foreign contributions in a way that was problematic. But they never could show that. And so, but people now have a popular perception that quote unquote interference is a crime because the media made it sound that way. They chose the word interference because it sounded bad, but actually isn't criminal. And so
it's also so muddy a concept. What is interference? Is it convincing someone to vote a certain way if you live outside the country?
It's notoriously vague, and it actually relates to maybe our second topic, the Missouri case, because I was just looking at that law, and to me, they don't make it a crime to brandish weapons in Missouri. They make it a crime to brandish deadly weapons in, quote, an angry manner. And I was like, what the heck is angry? How do you define angry? And I thought maybe there would be a statutory definition. Nope, no statutory definition. And I'm like, that strikes me as that statute should be challenged as unconstitutional, as void for vagueness. Because what's angry? I mean, that doesn't. I mean, you normally have something far more specific than that. I mean, imagine you can't brandish a weapon in an upset manner. Well, what the heck does that mean? So so these laws that are vague like this, and the way that election interference was vague to make it sound more insinuous than it was. Is similar to what the happening in the Missouri case, where the couple, the lawyer couple, that decided that made themselves into a meme with their gun, him with the huge gun, and she with the little tiny gun.
There were some amazing remixes. I mean, amazing in a comedic sense, but they replaced. There was a picture where they replaced the guns with guitars, and I think it was so. Okay, so what happened? I mean, what were there were no charges in that case. There was just a search warrant effected, and they seized the weapons.
They seized the weapons. So I'm assuming the only reason to seize the weapons is to bring some sort of charge. So what's a crime is it's actually a felony in Missouri to exhibit deadly weapons in front of a group of people in an angry or threatening manner. Now, threatening probably is sufficiently specific, but even that's a little vague. The best analogy for people to use is this. Could you bring the claim as a defamation claim if somebody used that word against you? And my view is if you can't, and the reason why they say you can't in certain cases is they say no jury could determine that as a fact. Well, then how could it possibly be an element of a criminal charge if no jury could conclude it as a fact in a civil defamation claim? So, for example, if I said George did something in an angry and threatening manner, I can't be sued for defamation because that's too vague. So how can you be criminally prosecuted for that? But so we don't know why the search warrant was executed. We don't know if but presuming the prosecutor had previously made statements to the effect that she was going to look at criminally prosecuting him, presumably it's a prosecution like the case of the people that were outside that store who also got prosecuted for brandishing weapons. But in Missouri, it's that they brandished the weapons in a threatening and angry manner, number one, and then they have to prove that they did not have a reasonable belief that their property was being trespassed upon, because Missouri has a very broad self-defense statute that allows any use of force of any kind, including actual force. I mean, there's examples where it's darkly comedic. It's like an episode of Fargo from the Coen brothers, which is, by the way, a great series if anybody ever watches it, on the comedic components of criminal behavior. But years ago in Missouri, a guy called in and said that his wife had found someone in their garage asleep in the car, and the guy said, "You better get here before I shoot the SOB." Well, ultimately, he just shot the SOB anyway before the cops got there, and it was found to be a justifiable defense, apparently. So there's a broad rule in Missouri. You go on somebody's property, they can basically shoot first and ask questions later. Here, he didn't even shoot. He just brandished the weapon. So the proportionality of force seems to be met. And they have to prove that he did not have any reasonable belief that they were unlawfully trespassing upon his property. Now,
if anybody doesn't know, I mean, everybody has to know what we're talking about, but it's that video of an elderly couple, multimillionaire lawyers, The husband is holding what looks like an AR-15, but I can't pretend to know anything about weapons. And the wife is holding what looks like a James Bond purse gun in a very awkward and in a very awkward manner. The way the news was reporting it was that protesters got into a gated community, and that these two homeowners basically got their guns and tried to scare them off. In reality, it seems that they were on their very property. They were within their own gates. It wasn't like on, I don't know, going through Century Village in Florida, and as opposed to like on someone else's front lawn. But they were right on their property, and they took out the guns. The video went viral. They came up with a statement through council afterwards, saying that they support the movement. They had no problem with anyone in the crowd except for two individuals who happened to be white that were threatening them. That's when they got their guns. And I made a sort of a tongue-in-cheek observation that, notwithstanding their public statement of support, they're still now faced with they're in a world where people want to defund the police, and the right to bear arms when they take them out to protect themselves when the police are not around. Now they're being criminalized for it, and it's
they want to defund the police and disarm the populace, and only allow the mob to have power, and only allow the mob to have the coercion of violence, and the state to have the coercive power of violence, but without the police. So it's a very sort of unsettling kind of environment to be in. Now, I think what they face, apparently there's disputes about what is and is not their property. Apparently they've been in this dispute with the trustees of the local community. So apparently they have been very litigious. So apparently, I think this probably informs some of the background. Apparently, like, he sued his, I think he sued his sister, he sued his brother, he sued a caretaker. So he doesn't lack for suits. Apparently he sued once because a birthday gift he got, he thought was real property transfer. So this guy doesn't lack. He sued his prior boss. He sued another law firm in order to get that property. So he's not bashful when it comes to the law. I think there was some ways they handled the court of public opinion I would have at least recommended differently, because they went on Tucker, which I think was smart, but then they also went on Chris Cuomo, and they went on Cuomo after they'd gone on Tucker, which was almost going to be a guarantee that Cuomo would go after him. If your goal was to persuade a Democratic prosecutor in St. Louis, and she's a Soros-backed prosecutor, so she comes from that political movement. Soros wanted to influence criminal justice by appointing a lot of left-leaning prosecutors to sort of weaponize the prosecutor's office for political purposes and what he believes would be a better world. I don't share his approach on that in many contexts, but given that to your audience you maybe take a different approach. I mean, if you're going to argue to a potential jury pool in the statewide Republican officials in Missouri, then you stick with a Tucker approach. If you're going to try to appeal to the Democrats, then you go on CNN and give them exclusives so that they don't feel the need to be hostile to you because their politics may be different.
Well, I've never heard of anybody going on Tucker and then not immediately getting accused of being a racist or a xenophobe afterwards, because it seems like if you show your face on Fox News, that is the invariable accusation that comes the next day.
Yes, and they're busy doxing anybody who even writes for Tucker. A writer got kicked off had to resign from the show because he was some anonymous figure on some anonymous message board that nobody really cares about, that CNN apparently decided to do a Watergate-level investigation on the guy. Like, they even looked at every single photo ever posted on this anonymous account to see if they could capture his reflection in one of the photos. It's like, hold on a second. Some low-level writer on Tucker is worthy of this investigation? There's no, like, politicians you might be investigating for real corruption, no banks, no big corporations. So I have a case that may be coming up in Missouri against one of the big banks in Missouri who's engaged in very problematic behavior and conduct towards my client. There would be something worthy of investigation. Instead, a couple of people who just walked in front of their house who are obviously scared just brandish the gun so people don't raid their house after what they've been witnessing on TV for 6 weeks. All of which, by the way, would be relevant. So I think they have a very robust defense because whatever they saw would be relevant to their state of mind. And so for that, what happened in CHOP, what happened at CHOP Chaz, whatever you want to call it, what's been happening in Portland, what's been happening in New York, Chicago, Detroit, Philadelphia, all these places where people are being beat up, people being assaulted, what's been happening in St. Louis, what's been happening around Ferguson over the last 5 years or so. So you look, I mean, they have great context to say we had every reason to believe some portion of this group was going to use this group as a mask to come in and invade our house. and cause us harm because we'd witnessed it and seen it repeatedly by similar members of similar groups dressed in a similar way under the guise of a similar protest engage in criminality in places like Santa Monica, California. So and all of that would be relevant evidence because it's relevant to their state of mind, which the government has to prove beyond a reasonable doubt that neither of them had any reason to believe that that there was any unlawful trespass or danger taking place. And there's no duty to retreat in Missouri. And so
everybody knows also we're talking the actus reus, which is carrying out the act of the crime, and the mens rea, which is having the mental, the requisite mental intent to have committed the crime. Yeah, to me, I couldn't believe it that they would even, because apparently they haven't been charged yet, but that they had even had a warrant issued and their weapons seized. It's nice. Now the Second Amendment is basically being defanged. If you have the right to bear arms, you just can't actually use them, except under what circumstances. And they keep raising the bar or lowering the bar, whichever way you want to look at it, to the point where it's going to be, you will effectively be criminalized for having a gun and thinking it's for self-defense as it exists in the States.
And it's clearly just going to help Trump because, now the jobs, not mobs, and that Joe Biden is mobs, not jobs, is becoming going to be easier to pitch. Because people are going to see that in the mob's context, that they really want to activate the mob, empower the mob, and remove all obstacles to the mob. And those obstacles of the mob are first the police, and secondly, an armed populace willing and ready to use those arms for self-defense.
And I did wonder. I don't know which way this couple leaned politically beforehand, but I do wonder if they leaned left. Are they leaning a different way now? And I just got news that my youngest kid learned how to swim, which is fantastic.
Ah, fantastic. That's great. I didn't learn to swim till I was like 8 because when I was 5, they took me to some crazy poor people's pool from our neighborhood where their lessons to how to swim was to throw you in the deep end. All that did was terrify me of pools for like 3 years. And so then I finally learned when I was 8. And I learned with all the 3-year-olds, which was just completely embarrassing. I'm the 8-year-old with these big like floats on, and the 3-year-olds are laughing at me because I don't know how to swim yet. But I did finally learn how to swim.
We didn't go with the traumatic way of teaching, but I think learning how to swim is the most important thing, because otherwise you are literally a liability around water. And it's
absolutely.
Okay, let me blast through these super chats, and then we're going to get to Flynn because I know people want to hear it. Sean Cleary says, "Is there a class action lawsuit that can be started against Twitter for stifling First Amendment?"
No, because the courts have said that the courts are closed to suing Twitter in almost every context. I've tried multiple occasions and got some reasonable resolutions in those individual cases, but the courts made clear they have no interest in pursuing Twitter on almost any grounds right now. That law has to change for that to occur.
We got Sean El Buco Loco says, "Did hospice centers violate patients' rights by blocking family visitation while keeping COVID patients there? Can anything be done legally for the people still suffering alone?"
I wish, but unfortunately, all the governors are immunizing the hospice centers and nursing homes and elder care centers across the country to make it impossible to sue them. They're giving them the same Democrats screaming, "Let's take away qualified immunity from police," which I mostly agree with. I think no politician should have any immunity, period. But we should start with the politicians. The very same people are not only demanding immunity for themselves, but are also demanding immunity for the nursing homes that they require to take these people under these conditions. So it's I've had clients whose elders died because of it, who cannot seek any legal remedy because the governors in those states have immunized the nursing homes from suit.
Madam Van Kook, I think I missed the chat, so I can't bring it up. But it says, if Antifa BLM attack voters at Republican, it just literally disappeared as I was reading it.
If she means at precincts, generally that's where where private action is in concert with the state, or if it's a private action that's at a voting precinct or things like that, that's where the law is much more robust. It's not so strong in other contexts, unfortunately, right now.
Okay, and we got Howling Mad says, "I was very disappointed when SCOTUS passed on all 10 2A cases. We have to be able to protect ourselves." I think a lot of people are realizing this now, and like Cernovich and other people on Twitter are saying, the discussion about gun rights now is off the table for a little bit of time until things calm down. Dapper Day says, "Why aren't these DA offices charged for ethics for violations with the ABA with these selective prosecutions?"
So the ABA wouldn't have control over them. The local state Supreme Court, in some cases Bar Association, but in most cases local state Supreme Court controls licensing, and they never do anything about prosecutors who behave unethically. I think there's been 2 instances when they did a massive study and survey of 2,000 factually documented court-determined abuses of power. only 2 were ever faced any kind of ethical punishment. So it's criminal defense lawyers who get punished. It's political dissident lawyers who get punished, not the systems lawyers, particularly prosecutors. They never get hit.
And this actually brings us into Little Rock Super Chat. RB, how do you survive in the legal field with a center-right mentality? Viva 2, I am attacked constantly in Little Rock for my views, and I am a criminal defense attorney.
Well, I have 2 fold advantages. One, I've represented people all across the political spectrum. So they were doing a documentary on the Covington case, and the guy doing the documentary said, a lot of people respond negatively when they hear you've represented Alex Jones. And I say, well, look, if you put up, I guarantee you that somebody that I have represented someone the audience hates, because I've represented people who hate each other. So I've represented far left, far right, center left, center right, center. So I have a little bit of immunity in that regard from legitimate political criticism. You're always going to get BS criticism because I have been in a position where I've represented everybody across the political spectrum. The second benefit I have is that I have been in a position where I've done a lot of civil rights cases. I still do. I still represent people across the political spectrum. My politics don't easily fit into too many neat categories. I try not to be hypocritical. So that means I don't believe in overcriminalization, period. So the abolition movement of aspects of BLM, I actually agree with, because in certain respects, I don't believe us where did we get the idea? Okay, you're young. Usually a person enters the criminal justice system when they're young, when they're 11, 12, 13, 14. People who end up caught in the criminal justice system long term. Where do we come up with the idea of, hey, the best way to treat these people is we're going to take them and introduce them to other criminals, make sure they get to network with each other, make sure they get ideas from each other, make sure they can associate for future purposes and develop relationships, and be around more violent criminals who will harm them in such a way that we will make them hardcore criminals by the end of the process. Yet that is what we do in America. That's our juvenile criminal justice system in a nutshell. It's insane. So we do need to have different systems of criminal prosecution and punishment, in my view. But because I have some idiosyncratic political viewpoints, it makes it harder for people to pigeonhole me legitimately. They can always do so illegitimately. I get people that, if it's someone on the right, they point out the people on the left I've represented. If it's somebody on the left, they point out the people on the right. So if the Daily Beast is doing a hit piece or the Huffington Post is doing a hit piece, they say Robert Barnes, InfoWars lawyer, Alex Jones lawyer, whatever. If it's people on the right, they used to say Robert Barnes, Wesley Snipes lawyer, Robert Barnes, Ralph Nader lawyer, Robert Barnes, Jill Stein's lawyer. It's always fascinating how they define you. They can't seem like when I started representing Amy Cooper.
Yeah,
they didn't know what to say. They didn't know what to do. They're like, oh, hold on a second, and so they're trying to figure out an angle of attack. And the fact that many people within BLM agree with me that she should not be prosecuted. The Kristen Cooper, the quote unquote victim, says she should not be prosecuted. Nobody from the New York Police Department really wanted her prosecuted. It's only the crazy mayor demanding her prosecution. That all of a sudden my political positions align with many people on the left. And it's also just in general, the idea that New Yorkers should criminalize each other for not being bashful when that's the definition of being a New Yorker is insane to me. I remember the very first time I was ever in New York City. I was riding a bus with my mom to go to my grandparents to work in the diner because my grandfather, when he found out that he could work 10-year-olds and not pay a minimum wage as long as they had some sort of family relation, he became a big fan. God bless him. So he had me up there every summer working, and in overtime apparently didn't matter to him and so forth. So there's a lot of things that are interesting with that. But beautiful diner though. It was the place where they filmed On Golden Pond and What About Bob? That later became my nickname at a governor's school project. This is a side tangent. But I was all excited to finally get to New York City. And we rode the bus. We took the Greyhound 2/3 of the way up and then Trailways the rest of the way up. Long. Riding the dog, they call it in the Greyhound. Right? A long trip to be on a bus. Not always great people on the bus, but some good people. But man, the smells on that thing. Thank God I didn't have a good sense of smell. But finally we get to New York City and my mom wakes me up and I'm all excited. I'm like, finally get to see New York City. I open my eyes, look out the window, and there's a guy urinating on the wall. So that was my introduction to New York City. And I always said, well, that was sort of an honest introduction to New York City. What I love about New York is its raw authenticity, honesty. It's not a bashful city. It's a brash city. It's a proud city. It's a passionate city. And now we're going to prosecute a dog walker in the park with a dispute with a bird watcher because somebody thinks she didn't use the politically correct terminology because she panicked in response to a situation. It's like, that's not New York. They say worse things to each other every day in New York. Go to a New York Yankees game back when they were having before the pandemic. They used to say the nastiest things to the other side all the time. Every sort of bad thing that you are never supposed to say, you would hear at a New York Yankees or New York Mets game, or a Giants or a Jets game or a Knicks game. That was just the nature of the animal. That's New York. You got to be strong and tough to handle it. And now they've become so soft and fragile that
it's beyond that. First of all, as relates to Amy Cooper, they are identifying you as counsel for Alex Jones. That's yes, what I've been seeing in all of the articles.
Yes.
Now I forgot what I was about to say. It was the fact that Mayor de Blasio posts that tweet where he says, "Good, now she'll face consequences for her actions. Had the police come, something might have happened." Someone made an interesting comment, like, it's as though Mayor de Blasio would suggest that if his police did something unjustified to a man because of his race, it wouldn't be the policeman's fault. It would be Amy Cooper's fault. And that's the level of faith he has in his own police department.
It's just insane. And not only that, even worse, this is one of the only criminal cases he has ever commented on in his entire career as a mayor. And number two, the judge that's going to be assigned the case will most likely have been appointed by him, because in New York, they have a Tammany Hall style system of judicial appointments, to where if you are handling a misdemeanor offense and you're a part of the criminal court system of the city of New York, you are appointed by the mayor to 10-year terms. And when I found this out, I was like, what? That can't be right. I was like, even in some of the craziest small towns in the South where we've got some crazy standards sometimes, we don't have that kind of judge handling a situation. And here you have the mayor openly and overtly interfering in the case and has been demanding her prosecution, even though Christian Cooper doesn't want it and opposes it, even though large groups and parts of BLM don't want it and oppose it, even though nobody in the New York Police Department is screaming for it, even though it's completely contrary to the history of criminal prosecution policy decision-making in the city of New York, even though it doesn't even appear to apply to the statute that she's being charged under. Even if all the facts were known, they wouldn't bring it. I have no doubt about that at all. Some of those facts came out this week. More will come out over the coming weeks. But just the fact that, what I knew that other people didn't know is that Christian Cooper wanted nothing to do with the case and didn't think it should go forward and regrets aspects of what happened. And now he came out and publicly said that this week, because the New York, it was amazing, is you had media pressure on this guy to bring a case he doesn't want to see brought, saying, because he understands that I have no doubt he would handle it differently if he could go back in time and do it again. He wouldn't use the language he used. He wouldn't use the rhetoric he used. He wouldn't have induced the situation. And he made clear from day one, he never wanted the consequences. He's just there's been a 50-year war in Central Park between bird watchers and dog walkers. I mean, that's just reality. All right. And there's been much worse circumstances. I mean, there's been circumstances where some bird watchers were poisoning people's dogs. I mean, it got insane. Once you go down that rabbit hole, you're there, right? The idea that any of it would ever be criminalized, I don't think anything had ever been criminalized before in the past, even though these have been long-going disputes and controversies. The Park Police, New York Police know what it is and know how to handle it, keep everybody cool, keep everybody calm. And historically, they've encouraged calling 911 because they don't want another Bernie Getz. They don't want people resorting to self-remedies. And so that's what she did. If you look at the New York criminal laws, the way they're actually written, for false reporting in the third degree, the first prong is creating a public panic. What's fascinating is that was clearly unconstitutional, but nobody in New York apparently ever thought to challenge it until this year. And earlier this year, the New York High Court said, oh, yes, clearly this violates the First Amendment. So that provision has been stricken. The second provision is if you fake an emergency. And what that's intended to do is for pranksters. So it's not about whether you get a fact wrong or legal theory wrong or anything else wrong about your interpretation of a 911 call, because they know people are calling when they're in a traumatic state of mind. And so they don't want to say, hey, if you call and get a single fact wrong, now we're going to prosecute you. Instead, they just wanted people to stop pranking. So, you get those 12-year-olds to say, I wonder how it'd be fun to see the cops call and see what happens. They wanted those people to stop. That's subsection 2 of the statute. She is not prosecuted under that subsection. Some people have believed she is. She's not. She's prosecuted under subsection 3. And subsection 3 says only that you can be if you lie to a law enforcement officer. That never happened here. There's no evidence of that, no allegation of that. So subsection.
I think one of the other ones was a quasi-official officer or something.
Well, what it says is law enforcement officer or agency. And so what that is like filling out a report. And also it requires it be gratuitous. So this is dealing like they didn't want to make it a crime if a cop suddenly knocks on your door and you get something wrong, all of a sudden you go to jail. They didn't want that to be a crime. They wanted to say if you voluntarily go into the local law enforcement office and other law enforcement agency. The reason why they have agency there is because it's New York, God bless them. So they have like 50 agencies that implement the law. So they wanted to make sure it applied to agencies that are other than just New York Police Department. So if you make a false statement, if you go in and file a false report with the park police or with the housing police or with the whatever other, they have so many different kinds of police in New York. Anything like that, you file a false police report gratuitously, you initiate and instigate that filing, then that is also a misdemeanor. That never happened here. Instead, they're trying to shoehorn the 911 provision under subsection 2 into subsection 3. And so it's problematic at multiple levels. I will say the whole process was handled very professionally by the city of New York in terms of how it worked that day. We had arranged it so that there would be no press attended, and they didn't violate that at all. Went in, you do your fingerprinting, you do your photographing, you do your booking, you do your identification, you fill it out. And they have in New York, in most places, you either get arrested, you have an arrest warrant issued for you, or you're arrested at the scene, or you get a summons issued for you for a criminal case. In New York, they have something called desk appearance tickets that are a substitute for those. And the main difference is it doesn't require judicial involvement, doesn't require a judicial imprimatur. Key law enforcement officers can issue them. And so that's what they did. But they were very professional, very polite, very proper, and no misrepresentation. So, and all of my experience in the past with NYPD, they're one of the best police departments in the country. They rarely do anything, in my experience at least, problematic. Now, other aspects of New York's system I've had problems with. In the Wesley Snipes case, where they falsely brought paternity charges against him, the whole system was insane. Local hearing examiners making crazy rulings, judge issuing crazy rulings. They had Interpol warrants out for his arrest based on a completely insane allegation they knew was false. They falsified statements about him in the press. That was my last time in digging into New York, and that led to the removal of certain judicial officials, government officials, and others by the time we were done, because I sued everybody in federal court. And this case will have this case will be much bigger than Amy Cooper. It's about misuse of the 911 statute by the mayor's office, or encouraging and incentivizing it. It's about Tammany Hall style justice in the criminal court processes that probably other lawyers wouldn't necessarily feel comfortable raising, but I don't have a problem raising. I'm not in New York every day, so I can bring up issues I think that are problematic with New York, that I think New Yorkers will find problematic. And I think down deep, when all the facts are known, most New Yorkers will agree that this is a case that never should have been brought, and hopefully it will be dismissed before we ever have to get to a jury trial. But if we get there, she will be acquitted once the facts are known.
All right. And I want to go with the selective prosecution versus malicious prosecution. Any chance of an argument for? See, I'm reluctant. I don't want to ask you too many questions because it's an active case and you're representing. But the question I'm wondering: all
options will be investigated. I have serious problems with what the mayor's doing. I'll put it that way. I've not been bashful about that. I've told him that on social media myself. I think your tweet response to him did not mince words. For anybody who hadn't seen it, I think I retweeted it, but it didn't mince words. And in my view, he should recuse himself from any further proceedings in this regard. If the man had any honor, he just resigned from the mayorship. Save the prestige of the city of New York. Mayor DeStasio should step down and quit embarrassing the city by holding that office.
And just so everybody appreciates, people have this idea about corruption that it's like literally like telling someone what to do in a cryptic email that you then burn. When it comes to this type of corruption, and I'm calling it corruption, everybody knows what is being said through what is not being said. And when the mayor who appointed judges comes on Twitter and says, good, now she's going to get justice. I mean, he's basically, there could not be any more overt pressure on a system to bring charges when your boss is on Twitter tweeting out to 4 million people, I don't know how many he has, that this is what he wants, so you better make it happen. And it's just so improper. There's no words for it.
Agreed. And, the Trump doesn't have anywhere to the degree of control over the federal judiciary that the mayor does over the criminal courts in New York. But anytime he's got close to saying anything like that, he's been rightly criticized in the press. And yet here's something that's far more egregious. The press has been strangely muted and silent about in the city of New York. So they made a lot of assumptions about her that put it this way, there's good reasons why Christian Cooper does not want her prosecuted. There's good reasons why no one in the New York Police Department's been screaming for her prosecutions, and they don't even know all the facts. When all the facts are known, people are going to regret the judgment they reached about her. They're going to realize they rushed a judgment, and they did. And one of the big reasons I took the case, because I originally passed on it, is I'm concerned about this far beyond the scope of this individual case, of what it could mean for other people. I'm concerned about what it could mean for women who want to call police and 911. But I'm really concerned about this attempts to create involuntary filming of private citizens in public places by creating a live reality TV, recreating a Jenny Jones Springer TV show like reality world. People should watch the Trial by Media Netflix show that gets into what happened with Jenny Jones. And when you dig into a lot of that environment, it created a very disturbing environment. And what happens with people who, like my nephew, who's autistic, who may struggle at times with emotional self-control, regulatory self-regulation, as many autistic kids do, when they become adults. If he's in the park and he responds in a way that the rest of the world says, well, we wouldn't have responded that way, but that's but his state of mind, that's how he reacts. Is he going to be publicly humiliated, publicly shamed, his life destroyed, his job ripped away from him, kicked out of his home, have to abandon the place that he has lived, and be threatened with a year at Rikers Island because of it? To me, the sickness is the people who want to engage in this. The fact this video has been watched over 50 million times, to me, is a disturbing thing. It says something about us as a people, where we should be pointing the finger at ourselves, not pointing the finger at others, or be so eager to do so.
I couldn't agree more. And I think this is the type of situation it's going to take for people to actually carry out the exercise when they see something online, to just hold off judgment, and not more than hold off judgment, hold off retweeting it, because there's videos that I see that I retweet, and they might be entertaining for other people to watch, but you have to think about what is going on. And I think this might get people thinking. Seeing the reactions and the comments to the videos I've made on the subject, which I think are relatively neutral, it's amazing. People just get themselves whipped up, and they shut off any idea of adjusting their initial reaction.
It's the old Elvis rule that he learned when he was 5 years old from his father. When Elvis said something harsh about a guy walking down the street, and his dad said, son, never judge a man until you've walked a mile in his shoes. And Elvis would repeat that as his sort of mantra for life. And I've always said it's a good mantra, that if we wouldn't want to be judged ourselves, none of us would want the worst 60 seconds of our lives to be broadcast to the world, period. That's humiliating enough. But the worst 60 seconds of our lives to become the judgment of who we are as human beings. And yet that's what we're doing to other people. And we shouldn't do to others what we would not want done to us.
Totally agree. And now a super chat, which is going to bring us into the next subject. In the case of Michael Flynn, what's the chance that Sullivan is removed from the case if the whole bench rehearing is allowed? So everybody knows the Michael Flynn situation. Sullivan filed a petition for rehearing en banc. It seems that it might have been outside of the delays, but maybe they're not counting non-juridical days. I don't know how the delays work, but it was filed on the 9th. And it's basically nothing more than a regurgitation of Gleason's arguments in his amicus, of Wilkins' arguments in the dissent, basically just saying all of the arguments rehashed. The Court of Appeal got it wrong. It's a serious enough issue. We need the full Court of Appeals to hear it. One of the main questions, one question that I had, and I think I know the answer, but let me know. Had the Court of Appeal reassigned the judge, he would have still had the same remedy to make a petition for rehearing en banc to undo the decision that reassigned him from the case?
Yes. So as to the specifics of the question, yes, the en banc court could either remand the proceedings and not grant the writ, or grant the writ and change it to require his removal. Both of those I think are unlikely. Now, I thought the majority of the DC circuit was GOP appointed, but it turns out I was mistaken. Majority is Democratic appointed. So that is probably why he has filed the petition for en banc review, is that they're politically aligned with him. The court did stay the case, which is unusual. Normally they don't stay the issuance of the mandate automatically, but they did do so here while they consider opposition. And I will still be surprised if they take it. I think it's problematic if they take it, but they may. If they reverse, I think it will probably go up to the U.S. Supreme Court, because somebody on the judicial side of the aisle has to make it clear that judges are not prosecutors, and not to open up this this can of worms, this Pandora's box. So, for example, I mean, a lot of people are saying, hey, he wasn't given a chance to rule and so forth. The real problem here was he was creating a special prosecutor's office through his amicus rulings and his suggestions of threats of criminal prosecution for contempt. So it wasn't just his delay in ordering the dismissal. If all he had done was not dismiss it yet, he would be in much better position. But he went much further than that. He said, basically, I want a special.
We're not losing Barnes.
Oh, can you hear me?
There's a bit of a lag. I'm just going to see if everyone is. Let's see.
Check.
Oh, yeah. Okay. I think we're good. Yeah. So sorry. Keep going.
No problem. It was probably immediately we start talking about Flynn. The CIA starting to get involved. It's extraordinary. The whole case is extraordinary. I mean, it and the Roger Stone case are two cases about how criminal prosecution should not occur in the United States, and they're extraordinary in what they're educating. But I was surprised he filed it just because it makes him look contained. Put it this way: the reason why he was not removed by the panel was because of their hope. Can you still hear me?
Yeah, but it's bouncing in and out. But I don't know if it's mine or yours, but we'll do this as long as we can.
Okay. The people say they can hear the person with Chinese symbols say they can hear me.
Okay, good.
So we're good. I mean, I can hear myself. So that always works as a lawyer, right? So I think as a component of it, I was surprised he filed it because he really made it clear that he should have been removed because he's not willing to get the message. But
it's crazy.
Completely.
The thing that drives me nuts, two things, and I said it in the video, but I'll say it again. He is accusing the Court of Appeal of expanding the scope of the mandamus or mandamus. Yeah. Now, I never did a mandamus in law, but I know that they're not like diamonds in the ground. They're used often enough as recourse. So it's not like that is being expanded in any unseen way. But that's exactly what he was trying to do with the the leave of court in granting a 48A. So he's accusing the Court of Appeal of doing the exact same thing he's doing. And the other thing that just drives me nuts is his consistent oversimplification, mischaracterization of what he was doing. I just wanted to consider both sides. I just wanted a hearing. You didn't need to hire an amicus, let alone that amicus. If all you wanted was a hearing, you could have the hearing, and I presume it's the same thing in the States. Judges can ask all the questions they want. They can be more proactive or more passive during a hearing. He did not need to appoint an amicus. He didn't need to schedule the hearing. He didn't need to add questions to the debate. I mean, in theory, he could have raised contempt on his own, I presume. He didn't need to suggest to a hand-picked amicus who's already shown animosity towards Trump and the process to do this. It's just crazy.
Completely. He chose a special prosecutor is what he de facto did. So he may not label it that, but that's what he did, to have the power of subpoenas, to have the power of discovery, to have the powers to leak to the press, to have powers to make statements he himself doesn't want to make on the record, but wants to have made on the record. And this has never been done before that I know of. And I haven't seen them cite a single example of this ever occurring. So clearly, if it had happened, they would have vouched for it with evidence. So I find it deeply problematic. It's unfortunate that General Flynn has to go through all of this to finally get vindicated. He should have been vindicated by July 4th. Instead, they bought a little extra time by how they interpreted the rules. So it got to be the day or so after the 4th that they filed the last possible minute they could file. They filed their petition. I hope the D.C. Circuit understands the environment they're in, that this is ill-advised, that they should just not touch it. But you never know. There are a lot of Democratic judges on that panel. So we'll see.
Actually, Aaron E. says, what does it say that Sullivan had to ask for en banc himself versus some of the other Dem-appointed judges doing it? Seems he waited to see and no one did it. Maybe that's why it took until the last minute?
I assume that, well, technically there still could have been another day or two for the other judge to do so. So I guess he interpreted the fact that it wasn't done right away by the dissenting judge. The dissenting judge could ask for an en banc review. So just that dissenting judge could cause all this process to occur. It struck me as he was really motivated by I mean, what I said back when we first did this is that he's a very arrogant man and that he's dumb as a bale of bricks. And I stick to both of those statements. I don't have confidence in his competence, and I don't have confidence in his ability to recognize that how he's being perceived. I mean, now for the first time, a Republican member of Congress is suggesting bringing impeachment against him in the House. Now, it won't go anywhere as long as it's a Democratic House, but as a federal judge, you don't want anybody talking about impeaching you. So somewhere along the way, he should wake up, but he's clearly in his own world completely.
And that is, a lot of people were asking what the remedy is. Can he be removed from the bench? Basically, the only way to remove a federal judge is through impeachment.
Effectively, courts can kind of do it. They have some supervisory powers to quote unquote suspend a judge. It's constitutionally questionable what the scope and scale of that power is. I've had the, well, I guess you could call it fortune to be in front of some judges who've been suspended for attitudinal issues and got the privilege of being in front of them afterwards. Let's just say they had not necessarily been cured, but it can happen. But generally speaking, the only clear constitutional remedy is impeachment.
Okay. And now I'm gonna read Vicky Rose's.
I should say I'm not in favor of his impeachment. I have the same standards as I did for President Trump. Yeah, it needs to be a crime. Now, the standard is lower for a judge. It's in good behavior, lower than it is for the president. But I'm not in favor of impeaching judges unless they've committed criminal conduct outside of their duties as a judge.
Yeah, and I can see that with this. I mean, I think it's egregious. People suspect corruption. People have all sorts of theories of, deep state and all sorts of other more sinister, but more unprovable suspicions. Bottom line, he might just be a stubborn judge who thinks he's right, and he wants someone to tell him he's right. I think
that's exactly who he is. I don't think he's corrupt. I just think he's very stubborn and he lives in his own world. And I think his clerks have badly served him here. Judges like Sullivan tend to depend heavily on their clerks. The clerks are overwhelmingly in that little lefty social media world. They have no clue. They're the kind of people who think defund the police is a popular political position to have.
The theory of corruption that I might have is why he filed the petition for rehearing. Yeah. Well, if he loses, at least the lawyers who are being paid by taxpayer dollars get to do their work and put 4 lawyers on this, put out a 20-page document. If it wins, it wins, and if it loses, they get paid. And Sullivan doesn't care. It's just
that's why I'm not in favor of this process. I think he should have done it all himself. Have his clerks write it. Shouldn't have been any private counsel involved. Should have been within the scope of his duties. He's more than capable of doing so with his clerks, and that's what should have happened. I don't like this private prosecutor process at all.
And so the next steps now, the delays that I wasn't aware of when I made the video, but the delays now, who gave Flynn and the DOJ 10 days to respond? Was that the
DC Circuit? But that can be done by a single judge's request. So even if just the dissenting judge in the panel decision requested it, then that would be granted. And the same with the stay. They granted the stay pending that occurring. So
explain what the stay means. The stay means that they're not going to force the issuance of the mandamus while this goes on. It makes sense because they couldn't get the result and then have it potentially be undone if his rehearing is granted.
That's correct.
Okay. So then 10 more days from the 9th. If it's juridical days, it includes weekends. Unless it falls on a weekend, then it goes to the next legal day, juridical day.
Yeah, we're probably talking about end of July, early August before this is wrapped up. Okay. And you never know. He may go up to the U.S. Supreme Court and request to stay the whole thing for the U.S. Supreme Court, which would push it to October potentially. So I do think the political objective here, I don't think this is Sullivan's objective, but I think the political objective of maybe some of his clerks is to force Trump to pardon Flynn. But I think, but the reality there is Trump can wait until after the election because even if he loses, he's in office until January 17th. And if people look at the history of pardons and commutations, most of them happen during the dead period after an election before an inauguration.
All right. If anybody's got any more questions about Flynn, we know what we're waiting for now. We're going to wait for the responses. They are going to schedule a hearing date, or is it going to be?
Did I rewrite that? I think Sidney Powell's already responded. I know she filed something in court. Maybe in the discovery, but I think she was ready to go right away.
Okay, well, we'll be covering that if and when something else comes out. But so they have 10 days to respond. They're going to respond. Is there going to be oral arguments, or is it just going to be written and the judges?
Normally they just deny the petition. They almost never, like in the States. It's interesting, and I think your pronunciation is the technically correct one. But in the States, we call it en banc. We actually pronunciate the C.
It's a French term.
maybe it was originally I think it's all because all these terms were originally Latin terms, and like if I recall right, French, Spanish, and Italian are all derived in some capacity from Latin. And some of our old legal terms were Latin in origin. But Only if they say yes. It's very rare to have an en banc oral argument. That almost never happens, even if they decide to grant the en banc petition. But generally speaking, they almost never grant en banc petitions. So I would be surprised if they grant en banc petition. But again, it is a Democratic majority on that circuit. So I would no longer be shocked if they do so.
Okay, interesting. I'm going to read these super chats before they disappear. Vicky Rose, we may not answer this one, but Barnes for later. What protection is there for citizens unwilling to take a vaccine that is being required by travel schools employers? I know that there was some disagreement on Dershowitz's position on that, but let's see.
It's where Dershowitz is right is that there's these huge loopholes in our law that gut all constitutional protections. He doesn't put it that way, but that's the truth of the matter. The logic behind mandatory vaccines was the same as used for mandatory sterilizations, was the same as used for the Korematsu of detaining the Japanese, and it's the same that's been used for the constitutionality of the draft. I agree that none of those things are constitutional. I mean, it makes no sense that, okay, you can't take away my First or Fourth or Fifth or Sixth or Second Amendment rights, but you can force me to go kill people. That doesn't make sense to me. So I don't agree with the draft being constitutional. It should be a constitutional amendment and it will never pass. That's why, that's the other giveaway. If something is clearly constitutional, why couldn't you pass an amendment to make it constitutional? Only if, in fact, it's something that we would never approve constitutionally. That's my problem with those kind of provisions. And so he's right. There's cases that have decided it, but they're all some of the most horrific cases in the history of our jurisprudence. And they're cases that are directly contrary to the plain language of the text of the Constitution itself. So it's not like we're in Eastern Oklahoma, which is now Indian country.
Oh, yeah, we're getting into that one. In fact, right before we do that, I missed Little Rock's super chat where he says, thanks for the expanded answer. I see the same as you and put up my background, not as lengthy as yours. I believe Jefferson said it best. Those who choose safety over freedom deserve neither. To your New York case. This is a Little Rock member. Thank you very much, Little Rock. And sorry I missed it. Let's go to, we'll go to Oklahoma now. That's perfect segue.
What's fascinating is before I even realized that case was before the Supreme Court docket, I was trying to explain to somebody a couple of months ago that an old buddy of mine is from Oklahoma. He's one of the top Native American lawyers in the country. And he told me, he says, Bob, really Eastern Oklahoma is Indian country. He said, if you really study the treaties. I was like, wow, that's fascinating. And I remember looking at it many, many years ago and agreeing with him. And my great professor at University of Wisconsin Law School, totally opposite politics of mine, has been very generous in writing extraordinary recommendations for me to judges and courts and other people. Richard Monette, a great Native American tribal lawyer. Indian law is what it's called within the American legal jurisprudence. That's why I use that phrase. And he was chief of his tribe for a period of time until the government didn't like him being chief of his tribe, so they came after him for a little while. He taught me a lot about the politics of law. He was my small section professor. What is in Wisconsin? When you go in, you are mostly in classrooms of 200 people or so, but you share all of your classes with a group of 20 who share one class. That's what's called the small section class, which is just the 20 of you. And he taught torts when we had great fun. I remember he gave a description once, and it was about a Native American guy comes up to somebody, asks to dance with his girlfriend. The guy says no, and they end up with a bar fight. And he says, and it was technically you were learning the tort of battery. But as we were going through, he goes, what's the lesson? What's the lesson? And came to me, and I was like, I know I'm missing what the lesson is. I somewhere here. He goes, he thought I would guess it. He goes, Barnes, it's simple. If an Indian comes up and asks to dance with your wife, you say yes. And I was like, oh, okay, yeah. So that's the kind of personality he was and is. I used to call it the railroad rule in torts, because if you study the history of torts in America, you study that all of a sudden it magically changed to favor railroads for about 50 years. So I used to say the railroad rule, which is that the railroad wins. That's the I don't know if you guys did IRAC in law school. So issue, rule, analysis, conclusion. That's how we were taught first year, right? So you had to identify the issue, what's the rule, what's the analysis to the facts, what's the conclusion, the holding. IRAC is the whole thing. So he would always be asking, what's the IRAC for different cases? And he always had a unique political take on it that I had often shared. But he wrote a great article called Treaty Federalism. And his point is that Native American treaties should be treated the same way that the compact between the states is treated in the federal government. And we should have a form of treaty federalism and respect the overlapping sovereignties between the two. So the Supreme Court's decision, people are thinking that it means that if you're in Eastern Oklahoma, your land is now owned by a tribe. That's not the case. This only under Congress's law, the federal courts govern any dispute involving a tribe member of certain kind, civilly or criminally, such that it can only go to either the tribal court system or to the federal court system. The local state government has no power or authority. The reality is the law, if you read it, was clear that Eastern Oklahoma was all tribal land, such that the state of Oklahoma did not have criminal or civil jurisdiction over most tribal members, and it only applies to tribal members. If you're not an Indian tribal member, this case has no impact on you whatsoever.
And so let me stop you there just to clarify one point. It was all tribal land based on treaties between U.S. government, federal government, and natives.
Exactly. The reality is we have not honored. I think the best argument for reparations in America is that the United States government, as a federal government, and a lot of state governments that have piggybacked off of it, have not honored our treaty requirements with tribes. So we made a promise, we made an agreement, we put it in writing, we should abide by it. And we have not abided by it, and with a lot of tribes over a large area of land, over a large area of time. And we violated those tribes' treaties repeatedly and routinely. Now, a lot of the genocide stuff is false. That was mostly a result of disease, not a result of deliberate intentional death. So I don't agree with the left on that side of the aisle. But we do have treaties. We've often not applied those treaties. We've often not enforced those treaties. We've often stolen property and mineral rights related to those treaties and not properly remunerated the tribe. And we often do not respect tribal sovereignty the way we should. There's a great show called Longmire that's on Netflix. In another life, I want to be the sheriff. That's the character Longmire. But they deal a lot with the tribal court overlapping issues and tribal sovereignty, which is very fascinating. Not always from a tribal sympathetic perspective, but does it better than most shows. And so, yeah, so I mean, technically, Justice Gorsuch's decision was, in my view, the legally correct decision. Congress can remedy it. Congress is likely to remedy it. They're already negotiating with the tribe to create a manageable system. Mostly, this is not about the Fed. Now, the particular case is horrible.
Yeah,
the guy committed a horrendous crime.
If everybody doesn't know, the individual who brought the suit was convicted of sexually abusing a 4-year-old.
Yes.
And the defense was that the state had no jurisdiction because he's a native, it's native land, and therefore only the feds could prosecute the crime. That's the obvious question. Why didn't the feds prosecute the crime?
Exactly. I think there's some backstory we don't know. Because to me, they probably chose that case because they figured the state of Oklahoma probably did, because they wanted the power to regulate Native Americans and the tribes and more broadly. Because most of these disputes end up being about taxes. 9 times out of 10, it's the state government wants to tax tobacco, wants to tax something else that's on tribal land. They want control over the tribal members. So they may have chosen the worst possible case, got the feds to say, let us, the state, prosecute it, because this will be a tough case for the courts to say, we're going to let them walk. But I don't blame the courts for simply applying the law. I blame the state of Oklahoma for not making sure that individual was properly prosecuted by tribal and federal authorities, who I guarantee you would have been happy to do so. Those kind of charges they don't flinch from. I think it was the state using a sensational case that they thought would allow them to have a massive power grab, and they almost got away with it. They got 4 justices to go their way.
Okay, I mean, so it makes a little more sense getting past the initial unlikability, to say the least, of the plaintiff and the underlying issue. Basically,
and the shock of discovering half of Oklahoma is actually Indian country.
So half of Oklahoma is native land based on treaties that the government has signed that had hitherto not respected. This decision, 5-4, basically says if you are native and you live on this territory, you are subject to the laws regarding the natives as far as income tax goes, as far as native status goes, and as far as application of state law, or I don't know if it's called immunity, but non-applicability of state law to federal law, and it only applies to natives.
Exactly. It's sovereignty that arises both from citizenship and geography. So it's territorial and citizenship driven. And it's if you are an Indian tribal member within the geography of Eastern Oklahoma, then only the federal government or the tribe can criminally prosecute you for a wide range of criminal behaviors. The state doesn't have jurisdiction over you because that's not their land as it applies to you as a citizen. because you're not a citizen of the state, you're a citizen of the tribe in reality.
And now, speaking of the tribe, actually, I saw the super chat and it was a relevant question. Mark Watson says, why is it all tribes and not just the Muskogee? Are many Indian treaties similar? So, I have no idea.
Oklahoma is very unique. I mean, Oklahoma was all designated as Indian country originally. So it's very unique history, the state of Oklahoma. So it would be analogous for specific treaties for specific tribes in other parts of the country, but Oklahoma is very unique. So the Oklahoma was originally promised, my recollection was when I researched this 20 years ago, as all tribal land, but it was clear that eastern Oklahoma definitely was. And we forcibly remove people. My hometown in Chattanooga, you go across the border to Rossville, it's named Rossville after John Ross, the great Cherokee tribal chief. There's still a home dedicated to him. Are you still there? I'm live, but I do not see Viva. I'll ask the people that are commenting whether they see me.
Stream. Okay.
There you go. You disappeared momentarily. I didn't know whether I was just me, just you, or what.
No, you insulted me on that last thing you said.
Yeah, exactly. That's it. The John Ross, the great Cherokee tribe.
I'm just that glad I got back in before I actually started sweating as it is, but I'm glad I got back in. Okay, sorry about that.
No problemo. So yeah, so that's the long and short history of it. So it depends on each individual tribe's history. Oklahoma is unique in the scale of the number of tribes it applies to and the legacy of the land.
And now, Robert, so a question I'm having based on my limited knowledge of Canadian Aboriginal law is recognizing half of Oklahoma going to have any impediments, or is it going to have any impact on non-natives' right to own land and develop land? Because that's
nope. So it will have no impact there.
It doesn't turn it into a native reserve.
No, it's interconnected. So it's citizenship and territory combined, and so it's not separate.
Okay, and I know I lost a couple of the super chats that were pending, but Joshua Kitchen says this discussion has changed my mind on the event. So it is not, because I guess some people were under the impression it turns half of Oklahoma into a native reserve.
Because the gaslighting sensational headline was half of Oklahoma now Indian country. And so I have a client that owns a lot of land in eastern Oklahoma. And so they're like, hold on a second. I was like, no, that's not what it means. It's a sovereignty of a government can arise either through the citizenship of the person, personal in personam jurisdiction, or through the land. In this case, it arises only in the context of both. Those people on that land equal only tribal or federal jurisdiction for certain purposes, because that too can be changed by Congress as how they pass the law.
What is the population of Native Americans in Oklahoma?
Not very big, very small.
Okay, so hypothetically, like the fringe benefit of what might have just happened is that all Native Americans living on the territory, all of a sudden, I don't know if they pay taxes in the states. I suspect they don't pay federal taxes.
They would pay federal taxes. The state taxes would depend on the circumstance of the situation. I think the biggest impact is mostly they can't be harassed by the local county government. Okay. And there is an unfortunate history in a lot of local governments. I clerked for a tribe in Wisconsin, and the local governments have an ugly history of how they've interacted with tribes over the past 50, 60, past 100 years.
Okay, amazing. Now, Roy Welsh says, would this mean that a tribal member is immune to a prohibition under state law if federal law doesn't prohibit? I.e., if it was in California and involved guns that were illegal in the state, but not by feds?
It can be. It gets really tricky. So, like, technically all tribal casinos are on tribal land, but sometimes they purchase land for that purposes that wasn't originally designated reservation land. And then they usually do a compact with the state to resolve issues in advance. It can get tricky with tobacco. It can get tricky with guns. It can get tricky with a wide range of areas. There was a question about whether, in my view, I agree with Richard Monette. I believe they should have the same sovereignty as the state. So, and that the treaty should govern it just like the compact between the states and the feds govern it. So there should be a form of treaty federalism in which they can do whatever they want unless prohibited by federal law from doing so.
All right, that's amazing. And Courtney Grace says, Viva, I have to say this has put a dent in wanting to find out if I'm part Kickapoo or Cherokee. It's amazing. People were. I didn't watch Matt Christensen's video on the subject, but did half of Oklahoma just get taken away? And is this how you start a civil war? I mean, I saw people on Twitter. I'm glad. I thought I understood it based on the articles. This definitely has clarified my understanding, and I suspect, based on the comments, a lot of people are more enlightened now as to what this decision actually means.
Yeah.
And my understanding is nothing for non-natives, and it might be confusing now for the natives in that a lot of them who have been convicted of state crimes might now get to go back and have new trials.
That's the biggest impact. Biggest impact is that their trials can get thrown out, in at least in the near short term. And I have no doubts that there's a lot of those cases that were problematic cases. I mean, just I dealt with a lot of undue hostility towards tribal members when representing and working with tribes in my legal career. So that was very ill-deserved and undeserved attacks. And it's long overdue that we recognize our explicit and express promises to them and at least abide by some of them, given we haven't abided by a lot of them.
All right. And actually, there was another interesting question right here. Can a sex offender be retried in federal, or does double jeopardy prevent that? I would imagine anyone who was acquitted of a crime cannot be retried.
Well, no double jeopardy applies, period, generally speaking, because a tribe is considered a separate sovereign. So just like you can prosecute someone in state court for, so that's how, like Rodney King riot, they got acquitted in state court, then they got convicted in federal court. The theory is that it's not double jeopardy because it's not the same sovereign. It's a different sovereign. And the tribal governments are also seen as a separate sovereign. So you can get prosecuted in tribal court even when you've been acquitted in state or federal court, and vice versa.
All right. And on civil law says, yeah, Brian, he can be retried in federal court, no double jeopardy problem.
Right.
Okay, that's interesting. I don't think there's any more.
I think Uncivil did a good discussion of the case.
Yes, the only problem, I couldn't watch an hour, 43 minutes. I was watching through it at 2 speed, but even still, I'm on my phone data by and large right here.
Yeah,
which
you're
is
out in the Canadian boonies. Though I think we're barred from going to Canada. So I saw a friend of mine's a professor in Canada. She's more to the left, and I think she was celebrating that the Canadians are blocking the Americans from coming for at least a period of time.
Oh, yeah, the border is still not open to non-essential.
That's insane.
It's. I remember when they shut the border. That's when I really started having apocalyptic thoughts in my head. Like,
could you sneak across the border, like pretend you're fishing on one of the lakes and come across?
I could literally swim into the U.S. from here, but I suspect they have something on the border that protects from boats drifting into the American side. Actually, before we get into the next subject, there was one super chat that I missed, and I wanted to get to it. Brad Patterson said, "Have either of you heard of the investigative journalist Lee Stranahan? Has done extensive work on BLM, Black Panthers, Russiagate, Ukrainegate. Please, can you give him a chance? You will be absolutely shocked."
Yeah, I've had my disagreements with Lee that have been pretty public. At times, Lee is a useful, cantankerous interviewer. That's an old school journalist of the kind I like, sort of wearing an overcoat, asking the haranguing question for the 25th time, but that needs to be asked. And then at times he goes off on a tangent that is not always productive. So and he thinks that if you disagree with him at times, he treats you like you're his personal enemy, that you're conspiring against him, things like that. So we went around and around in DC a couple of years ago. I generally still like Lee, even though he causes problems for friends of mine. I think he gets some things mistaken and doesn't always distinguish between disagreement and conspiratorial strategies and whatnot. So I pardon him that the reference. He's made some very mean comments about me over the years, but I think he mostly means well. But he gets some stuff wrong. So he's done useful stuff. He's been in Oliver Stone's films about Ukraine. He understands Ukraine well. He's researched that topic thoroughly. Now, he got sued along with Alex Jones for comments made related to the Charlottesville matter. I think those comments were misinterpreted. I don't think he did anything tortiously, intentionally wrong there, nor did Jones do that. But that's it's his nature. He's he's a throwback, and everything good with that, everything not always fun with that, you get. I do follow and track a lot of what he says, and I like some of his research investigation. He does populist.tv, etc. And even though he routinely bashes me, I still like Lee.
I've only heard of it indirectly. I have not read much on it, but I know what people are talking about and retweeting on Twitter. Justin Trudeau, the case is Roxham Road, Viva. You can still walk across. Okay, so that really does it for the Oklahoma thing. I hope everyone has gotten everyone's gotten what they need out of that. That's amazing. Let's do. We're going to run out of time soon.
We had the 2 SCOTUS decisions
Yeah,
where
so
they
let's
really helped Trump. Like, here's my conspiracy. If I was an anti-Trump person, my conspiracy theory about the Supreme Court would be different than the conventional theory of both the left and the right. The left celebrating Justice Roberts, the right ridiculing him, would be that they helped him tremendously. Because, like, imagine a Supreme Court that said you can discriminate against people for being gay, that you can kick out kids under DACA and send them back to Mexico tomorrow, that said that the president is above the law and his tax returns can never be gathered ever, that screwed over Native American tribes and rights. If it had done all those things on those and said that abortion is going to be overthrown, all of that would have been probably politically problematic for the president because it would have activated the left and would have been months of bad news. In contrast, by making those decisions, they removed those from his plate so he doesn't have to bear the burden of them. While at the same time, they gave incredible protection for parochial religious rights in schools and getting scholarship funding. They expanded the rights of religious people against certain forms of discrimination in the case of the contraception case, which was far more impactful for everyday Catholic operations than any other decision the Supreme Court made this term. And on big fundamental social change issues, they actually ruled in favor of Trump's constituencies and delivered for his 2 appointments because those were the deciding votes in many of those cases. And at the same time, they delayed the ability for them to collect these records. So while they said, hey, Congress can get his tax records, but it needs to go back and they need to look at all these issues. And the New York District Attorney Office can get his tax records, but they need to research and make sure it's all done properly and correctly. What does that mean? It means nothing's going to get disclosed before the election, which was all Trump was really aiming for. They can make whatever hay they want to afterwards. Politically speaking, this Supreme Court term at the end was a huge win to Trump, even if it isn't seen as such.
So that's one thing that I sort of want to get into, because I think, I don't know, I suspect most people thought they were going to judge on the side that he had to disclose his tax returns, that it would not be protected information.
Correct.
Now, remand, when they say they remanded to the lower courts, what does that mean exactly? Because they've rendered the decision, they've issued their judgment. What aspect of it are they remanding to the lower court?
They really partially reversed him. So they partially reversed in both cases because they said, no, a lot more information needs to be looked at before you can allow either Congress or the New York Attorney General's office, the New York DA's office, Cy Vance, to get these records. So they're more skeptical of Congress than they were of Cy Vance, because they assume Cy Vance will honor grand jury secrecy and the rest. I don't know if I would be that confident in Cy Vance. People should look up his criminal prosecution of the Abacus Bank, who he tried to scapegoat for the issues related to the financial crisis. He managed to not touch a single institutional big Wall Street player, but go after the small little Chinese bank on falsified charges, in my view. 240 not guilty verdicts, incredible outcome. But essentially the way they reacted is, hey, apply general grand jury rules and make sure you're not abusing your power and you can look at this. But for Congress, you really need to look at a whole bunch of things about legislative subpoena power. It does need to relate to a legislative purpose. It does need to make sure it can't be abused, so on and so forth. So the net effect of the remand was you can't get these records right now. There needs to be another round of litigation about this, what you're seeking, how much you're seeking, why you're seeking, what will be disclosed, when will it be disclosed, under what terms will be kept confidential. The net effect of which is going to be there's going to be no turning over any documents until after Election Day. So the knowing that probably the real intent of at least some of the people involved here was to leak these records once they got them, they made that impossible. Now, my personal view is there's been a wrongful quid pro quo being applied here in general on tax records. I agreed with the president's core position, but I didn't think it should be unique to the president. My view is tax records should never be subject to discovery, period, in any case, civil or criminal, unless it's a tax case. And the reason for that is the pitch has always been made, hey, we're not forcing you to incriminate yourself against the Fifth Amendment right by requiring you to file a tax return each year. And hey, don't worry, we're never going to abuse this power for politicized purposes by looking at your records for anything other than tax review. So that's why we can require you to disclose this massively invasive information. There's a great book called Confessions of a Tax Collector. Of course, I do a lot of tax cases. This is why I'm into this area. But Confessions of a Tax Collector, which reads like Lord Conrad going into the heart of the jungle, which is also a great book about abuse in Africa, which relates to vaccines. But that's a whole nother story for another live stream. Was AIDS caused by a wrongful vaccine? May become relevant in the constitutional context of challenging vaccines if that becomes an issue in the near short term. But the Confession of a Tax Collector, he detailed how he knew almost everything about your life through your tax records. He knew about your closest relationships, your family relationships, your significant others, who you live with, what church you give to, what campaign, political party you contribute to, who you're affiliated with, who you're associated with, who you're attached to, because you disclose these pieces of information on your tax returns. Very invasive. And the whole pretext is, hey, we're only asking this for tax collection purposes. And now what do we see? We see Congress and the Attorney General's office, and they're not looking at it to see whether Trump complied with the tax laws. They're looking at it to see whether there's any politically embarrassing information in those returns. And that's why they didn't really make that argument. They made more of the presidential argument, which I didn't think was the most persuasive. That's the argument I would have made. I would have made that tax returns should stay secret completely unless it relates to a tax case, or otherwise we've broken our promise to the American people in terms of inducing them to disclose confidential private information under the guise that was solely for tax collection when it's not being used that way.
Okay, I think I got that. So basically, what they don't get access to everything and anything. They have to go back now, replead before the lower court to say we have authorization to get.
What they said is you can get tax returns, but it's limited. And here's all the ways. The same rules that apply for anything else apply here, and some additional rules apply because we don't want abuse of power and we want to recognize separation of powers in the case of Congress. So the broad question was, can you ever get tax returns? They said yes, but they said, but that doesn't mean you can always get them. There are limits in time when you can get them. And those issues are yet to be litigated, because the only issue litigated to date was, could you ever get them?
Okay, so they're going to go back down. They're going to argue relevance, scope,
privacy, materiality, abuse of power,
whether anything can be redacted if it's not germane or private. And then the judge lower court is going to have to issue a judgment on that.
He's probably going to have to do some in-camera review, look at which part of the because remember, these are Trump's returns, multiple corporate organizations, multiple individuals. They're probably thousands of pages long. So there could be some returns that are relevant, some returns that are not, some entities that are, some entities are not. There's going to be other people's privacy interests implicated other than the president's in his corporate returns. So like if they just ask for his individual returns, that'd be different, but that's not what at least Cy Vance is asking for. They're asking for a whole bunch of corporate entity returns, which implicate a whole bunch of different interests. Are you still there? You look a little frozen. Can people still hear me? Just put in the comment section. Okay. So it looks like Viva's going to have to come back. So that's the short answer on the criminal tax case or the quasi-criminal grand jury case from Cy Vance. That is also still the context for the congressional inquiry, that they can get the president's records, but they have to meet a higher standard than the standard they've done so far. So there'll be continuous litigation. I think Viva's going to try to hop back on here in just a second. And so that's the SCOTUS update. So we covered, let's see. Someone asked, I'll answer any random question in the comments. So ask away. I see a lot of yeps, yeses and yeps. Canadian internet. Yeah. Ah, there you are. You're back.
Sweet, good. Yeah, and you know what? The whole family is now.
There you go.
Oh, God, you're pulling on my earbud. Okay, everyone get out. I'll be done in 5 minutes. Go. Get out of here. Okay, sorry about that. So I missed it, but I'm going to go back and re-listen so that I can get an answer to the question. Sorry about that, guys.
So is he the one who learned how to swim?
This is the one who learned how to swim.
Congratulations.
What do you say? Oh, actually, I have to take this out. No, I'm not going to take that. I'm going to mess up the earbud. He says congratulations. High five.
That's
Underwater. You have to swim above water, otherwise it's not swimming. Hey, get out of here. Hold on 1 second.
No problem.
Go
I
home.
think we're going to try to do to the question about
Okay, go.
OJ.
Give me my earbud back.
I think I was answering the question about OJ. We'll do the OJ when Viva has time to review some of the.
Yes, I have
unique
not
facts
yet
of the
done
case.
that. Okay, so I think now the question I had before we went down was that the judge will render his decision, his or her decision. I don't know who it is. That decision is going to be susceptible of appeal as an objection. Okay,
Probably
so
sometime within the next year, they'll come to a resolution about what records can be disclosed. The question will be, will they still be obsessed with getting these records when Trump is not running for re-election anymore? And I think there's some reasonable skepticism by the Supreme Court and others that these records won't be of sudden interest when they, is the pretext. Everybody's like, hey, we're just doing an honest criminal investigation. We're just doing an honest legislative investigation. I think the Supreme Court has some suspicion that that is not the case, and that once the re-election time passes, whether he wins or loses, that suddenly there won't be some compelling legislative purpose or grand jury purpose with Cy Vance, who may not even be prosecutor. He may not run for re-election in 2021 in New York. I hope he doesn't, but that's my own view. He brought an indictment against my client, so I can't thank him for that. But I think so. We'll see how all that unfurls and unfolds. But that's the long and short answer.
All right, and I read somewhere that one of the interpretations was that this information now, even once disclosed, is going to be more difficult to leak for some reason.
The nature of the ruling was such that privacy was supposed to be expected to be protected. We'll see whether that happens. They were particularly concerned about Congress, and they're right, because I don't see how Congress leaks everything. So I don't. But when there's no election, maybe they won't leak it.
Very interesting. Okay, was there another SCOTUS one that we had to deal with?
No, I think there was another SCOTUS decision, but it was not it was like when I was looking them up today, it wasn't one that I remembered off the top of my head of being of great consequence.
Okay, good. So that's interesting. So and I was reading the interpretations that this ruling, which looks like a defeat for Trump, is in fact a strategic win in that it adds endless delays, which is it's amazing. I don't know why. I've been saying that he should release the tax records from the beginning, just because I think that's a reasonable expectation when you run for public office, given historical practice. But it's an interesting fight, and there's good reasons now. One can see that the fight is being dragged on more and more. But
my own view is, because I have a unique approach to taxes, I've always felt I was glad that Trump refused to disclose, because I don't like this habit of treating tax returns as information that should be used for any purpose other than the collection of tax. And if it's for any other purpose, then in my view, the tax laws are being misused and abused.
Yeah, but the argument is going to be that when you're running for public office, people want to know, people have the right to know, where you sort of sacrifice or forego that aspect of privacy, and people need to know who you might be indebted to.
Right. And I think for that, it's more of an argument of for that, what we should do is we should change our financial disclosure laws. So rather than require tax returns, just require disclosure of anyone you owe a debt to, disclosure of anyone you have an ongoing contractual business relationship with. So I think that's very reasonable. But I think that should be part of our financial disclosure laws. We have some, but we don't. We require stock disclosures, things like that. We can require more, and I'm all in favor of that. But that should be separate from piggybacking off our tax laws in a way that effectively makes our tax laws forced self-incrimination on a routine basis for purposes other than collection of tax.
Very interesting. And I'm going to get to 3 super chats here before we get to the end. If all 50 states can charge murder for harming an unborn, does that mean that the unborn has separate inalienable rights? If so, how can abortion without due process be legal?
I mean, in my view, we should treat life the same no matter what, and we should treat life the same when it starts and when it ends. And we determine life ends when there's no brain activity. So when there's brain activity, we should recognize that's when life has begun and balance accordingly. But that's not what the law does. The law effectively separates out the two. So it sees it as a choice matter. So it treats it as kind of a life when it's involuntarily taken from someone, whereas it treats it as not a life when it's voluntarily taken, if it's a fetus, which to me is not a morally or legally consistent position, but it's the one we currently have in the law.
All right, that's a good answer. Matthew Hammond says, how do we handle the Soros DA's moral policing by charging the victims over the mobs?
It's all about mob empowerment. It's the French Revolution. People probably would benefit from studying the French Revolution. It was the first real attempt to leverage the power of the mob. The first communist movement was the Paris Commune of 1848 that paralleled and mimicked the tactics of the French Revolution in using the mob as its source of power. ultimately resulting in the Russian Revolution in 1917, of course, in St. Petersburg. And in fact, the reason why there are such beautiful broad streets in Paris today was to defang the mob. Napoleon III decided no more small streets where the mob could hang out. We're going to build big, beautiful streets, just to make sure no more mob power could take place. But this is an attempt to weaponize the mob, and in my view, to weaponize the criminal element within various communities, to give them more power over their own community for political purposes. So, and if you believe in certain aspects of the BLM, Marxist founders of BLM believe in, they think that's necessary. I mean, there's a reason why Stalin was a criminal before he became a communist. There was a certain overlap of appealing to private groups with skilled violence techniques to overthrow the state. So that's why it's happening. And it is deeply problematic, and it needs to be pushed back upon at all levels, both by not defunding the police and also by, more importantly, allowing a educated, armed populace to defend itself and defend the country.
Okay, amazing. And it's an interesting thing, like we've discussed, the judges that get elected versus the judges that get appointed, and both carry with them certain risks of corruption, different types, but they both have the risks. Second question, actually, someone was trying to draw a link between Oklahoma and Hawaii. What does the Oklahoma ruling mean for Hawaii?
To my knowledge, it doesn't mean anything for Hawaii, because I don't think it's there. There are specific, unique dynamics about how Hawaii was founded as a state. There's also unique tribal aspects there as well. But I don't think the ruling itself has any natural impact, as far as I know. But I haven't researched it in particular.
Okay. And Kelly Graham says, where did the whole providing tax returns expected when running for office start?
Richard Milhouse Nixon. Interestingly enough, he partially started that because as I told people back during the campaign in 2016 when it became an issue, I said nobody else did this. LBJ, no way he was disclosing his tax returns. He had interest in all kinds of active interests that were regulatorily impacted. No way John Kennedy was disclosing his tax returns. That was a man with all kinds of interesting connections. And I mean, if the family had to disclose those tax returns, people should look up the Vlad TV interviews of Gianni Russo, who played Carlos in the Godfather movies, and you can hear about a lot of interesting stories in that regard. So, it's a very modern phenomenon, and in my view, it's easy for politicians to do because most of them only get rich after they leave office magically. Trump was unique in being rich before he got here in the modern era. Now, during back in the Kennedy and Roosevelt days, that was the norm. But since Nixon, it's mostly been career politicians who've sought and obtained power. Kind of not Ronald Reagan, but the rest, for the most part, did not gain power independently economically, or they had their money tied up in trust, so you didn't really know it. So they would disclose their personal tax returns, but those were not highly educational. Like John Kerry, I think his wife only disclosed a little bit of info when she was the inheritor to the Heinz fortune. So my own view is the better approach is financial records of specific kinds that we pass through Congress, because what we want to know is what are conflicts, not necessarily what you have to disclose for tax purposes, which is a whole different animal, which won't even disclose most contractual relationships or conflict-related issues.
Very interesting. Now I think I just realized I never knew that Richard Nixon's middle name was Milhouse, and now I'm never going to look at The Simpsons again the same way.
Yep, exactly.
Okay, we got Mandalore Wise 01 says SCOTUS and faithless electors mid last week vlog soon. I'm going to look into it. That's
I was writing about that in 2016. It was an insane interpretation. It was the first coup attempt against Trump, which was, hey, the Electoral College, you don't really have to do what your state did. You can vote for Hillary Clinton. What they did not expect, of course, is that the most faithless electors were people who did not vote for Hillary Clinton, who were supposed to. She got the highest faithless electors, I think, in 100 years. But the Electoral College is an anomaly that I believe their duties are ministerial, and the state can limit what they do and how they do it. And the Supreme Court's decision was correct. It's what I predicted 4 years ago would happen. It just took 4 years for the Supreme Court to say so, which was that electors do not have the independence to ignore what their state told them to do.
Okay, amazing. Jay Mills, separate topic, is blocking the use of an app like TikTok a possibility in our system? Would they have to break it apart and show the malicious code?
It's the whole issue of Chinese government complicity and ownership. So the more it's a foreign policy that's really being implemented, the more power they have, the less foreign policy it is. It's the same as the Soros decision, whereas they are able to impose restrictions on Soros's organizations around the world, his international ones, that they can't impose on his domestic ones. So like his international ones have to oppose slavery and prostitution. His domestic ones do not, because the domestic ones are protected by the First Amendment, where the foreign ones are not. And so it's similar, the same logic. The TikTok, to the degree that they're imposing foreign policy, they have much broader constitutional discretion. To the degree it's domestic, they don't, and nor should they. Because I'm not in favor of all these laws trying to restrict foreign governments, trying to impact our U.S. elections, as long as it's public and open and transparent. I'm not as concerned. That happens anyway. Pushing it underground is just going to allow the more sophisticated and the more criminal to have the greatest import and influence without us knowing about it, without transparency. That's why I have issues with the Foreign Agencies Registration Act and other things like that. But yeah, that's where the constitutional discretion is shaped by whether he's trying to do foreign policy or domestic policy. It's clear TikTok is likely heavily influenced by the Chinese government. There's plenty of evidence in the public domain for us to draw that conclusion at this point.
I got another reason to tell my daughter no. We'll stick to Instagram.
Exactly.
We got Dapper Dave says, Robert, can't the Trump Corporation itself as a separate entity block the disclosure for the New York attorney attempts for the taxes? They're
attempting to. The difficulty is organizations and corporations have less power than individuals. I agree with that, by the way. I think in fact, I think corporations should have even less power, because my view is they're charters that are the privilege of the state to even operate, that provide extraordinary immunity from liability for the individuals who participate in them. And so to me, they can be held responsible and accountable and have limits that individuals do not, because they're not in the same context. They're really a state entity, in my view. I agree with Ralph Nader on that. But the law is sort of mixed at how it applies. So it's more to the degree that it impacts the privacy of other individuals, that a tax return by its nature will always impact a whole bunch of other people, because it discloses information about private citizens inevitably. So that's why it's hard to do any kind of tax record analysis without getting into the private information of third parties.
Okay, amazing. And now I think we're going to wrap it up now, but I'm just going to get to the last super chats. We're not going to answer them, but I'm going to read them and just thank you all in any event. Would any of you like to look into the dash cams diapering from the Sedalia, Missouri sheriffs?
I don't know about that, but that looks interesting.
Sir Barnes, can you show us one of those neon green books behind you?
Yes, they're magical.
We got Me Flowers here. This is just a super chat. Thank you very much. And I think that's it. We'll stop at 2 hours, because I think I do at some point have to go back to other duties.
Yes,
but
indeed.
Robert, another amazing live stream. It's fantastic, and I think people are going to get a lot out of this. Anybody wants a pinned comment, if we do a breakdown of the timestamps, that would be greatly appreciated. In the interim, I'm going to post all of Robert's links in the pinned comments so that everybody can know where to find him, where to access him, and where to follow him. Robert, thank you very much. Hold on, let me just get this off. Don't go. Also, we'll stick around afterwards, and we'll say our goodbyes. But everybody in the super chat, everyone in the comments, I tried to get to as many comments as I could. I bring up the comments. Thank you all for the support. Thank you for tuning in, and go enjoy the weekend. We'll do this again next week, most likely.
Yep.
Robert, everybody, have a good one.